First issue. Now the first chapter you'll see is an introduction, so I'm not going to spend a huge amount of time on that, but I explained in my outline for you, or my overview of the course, the importance of the topic. And really, constitution interpretation doesn't appear on his reading list, and you can access his reading list on the King's Inn's website, and I suggest that you do, to make sure that you see the journal articles and you see all the cases that John is focusing on. They are in the manuals, the cases, but you should have a second look yourself at them, and you should also look at the journal articles. Actually, some of the journal articles you may have already looked at in your undergraduate course, and you could whip the notes out and transfer them into your folder for the bar entrance exam. So look at that. Now, the introduction here basically focuses on two things. One is the methods of constitution interpretation, and the other then are some just general principles regarding constitutionality of legislation and judicial review, looking at the constitutionality of legislation. Now, that isn't per se listed in John's list of examinable topics. That's why it's not actually one of the topics on his list. But you needed to be able to answer some of the questions we say, like on personal rights, or a theory question on separation of powers. You'd have to have an understanding of what those principles are about. So what's in this introductory chapter is not technically on the course, in that it's one of the topics on his list, but it does impact in how you would answer certain areas throughout the course, so you need to be familiar with it. Okay, so it very much is background information that you may have to pull in when you're talking about what I call the more philosophical questions, like personal rights or proportionality, or if you got a statement philosophical question on separation of powers, it would come in there as well. You'll see what I'm talking about as we go through it. So I'm going to not spend too much time on the introduction, and what I'd ask is that you take a look at it yourselves. Okay, in a fair amount of detail, and come back to me if you have any questions. So what I'm going to do is I'm just going to highlight particular aspects in here that are important and explain it to you. So it would be very, very surprising, seeing as it's not listed as a topic in his syllabus, that you would get a question on constitutional interpretation. But obviously, in any discussion, particularly of how judges interpret rights, the method of interpretation they use can impact on the actual way that right is going to be applied by the judge in the case. So do you all see how it comes in indirectly? Okay. Now, some of you may not have focused on this much in your undergraduate degree, because lecturers can choose themselves what to focus on. So hopefully this isn't absolutely brand new to any student here. Okay. And if it is, you know, you probably may need a bit more time on it, and I can give that to you. That isn't a problem. Okay. Actually, I'm always in the college Monday to Thursday, 9:30 to 1:30. So if any of you were ever in the library and you were having a bit of difficulty with something, you can ask the librarian to ring me, and I can meet you somewhere. We can go over something. So don't ever be stuck. I am there Monday to Thursday, 9:30 to 1:30. Okay, first thing we're going to look at then are methods of constitutional interpretation. Now, the first thing is, and this is all contained in the manual, so I'm really just going to talk you through it and highlight particular paragraphs that I think are important. These methods of constitutional interpretation, they really have just been developed by the judges over the years. Okay? Now, what started to happen is academics who love to theorize everything started to say, well, actually, are these operating as a form of judicial restraint? So what if you ever got a question, we'll say to do with proportionality or to do with personal rights, where John mentions judicial restraint? And what I'm talking about is, we'll say, a type of statement questions that judicial restraint is lacking in the way that judges apply personal rights and the way that they apply the principle of proportionality. Okay? Now, what he wants you to talk about there is how personal rights are interpreted and applied by the judges, and on the principle of proportionality, which we'll look at later, is how are they getting the balance right where you have two competing interests in relation to a particular right. Does everyone understand what I'm saying? Okay, now would you all have a heart attack at a question like that? Well, what I want you to realise is that constitutional interpretation is sometimes seen as judicial restraint also. Mechanisms to rein in judges. And what do you think we're trying to rein them in from? Making the law and subjectivity. Okay, you don't want a particular judge who's anti-abortion defining right to travel for a termination case on the basis of his own personal views. We want him sticking to precedent case law or to looking at other jurisdictions and to making an objective determination about the issue in front of him, not a subjective one. Okay, now with that in mind, what I would ask is that as we go through cases, you maybe keep in the back of your mind, well, look at what method of interpretation is a judge using here? Because they don't always say, hey, listen, guys, I'm actually using the harmonious method of interpretation in this judgment. But you should be able to see, as you become familiar with the methods of interpretation, you should be able to see, he's using the harmonious one because he's looked at a term not just on its own but in terms of how it was used in other articles. Or maybe you'll see him a judge interpreting a word and he's saying, well, you know, the whole purpose of this provision in the Constitution, you can go, that's the purpose of approach. So what I want is that you just keep these different methods that judges can use to interpret the Constitution. I want you to keep them at the back of your mind. Okay, as we go through the course. And again, remember, they're often seen as a form of judicial restraint. And you'll see that this is discussed here in the manual for you in 102 about whether it really does operate as a restraint. Like, can you really keep subjectivity out when you're asking a person to interpret a particular provision? They're going to have their own beliefs, they're going to have their own opinions, they're human. Can you actually eradicate subjectivity when it comes to interpreting the Constitution? And the manual discussed that in 102. Now then we're going to go through, we're going to look at the various different methods. You just need to be familiar with these methods. As I said, you're not going to, based on his syllabus, get a question where you're asked to discuss the various methods of constitutional interpretation. Okay, the first one is the literal. And for those of you who are familiar, what it basically means is the literal meaning of the text is the one that's used. So you give, when a judge is asked to interpret a provision in the Constitution, he gives the words their plain, ordinary meaning. And one of the leading cases on this is DPP versus O'Shea, which is there in your manual. And that basically involved looking at the use of the meaning of the word all decisions in Article 34.4.3 of the Constitution in terms of appeals from High Court to Supreme Court. Now, what we want to take out here is really the quotation. The very important bit is the quotation at the end in paragraph 105. Now, this is where the court, O'Higgins CJ, summarised the court's position in terms of the place of literal interpretation when defining provisions within the Constitution. And he said that these words, where the meaning is plain and unambiguous, must be given their literal meaning. So the literal meaning is only really relevant where the words are plain and unambiguous. Now then, on the next page of in the quotation, page 6 of your manual, the judge qualifies that. What happens if the meaning isn't plain or unambiguous? What then are we supposed to do? Because we're only supposed to use the literal method when the meaning is plain and unambiguous. Well, the court tells us. It says, where doubt or ambiguity exists, regard may be had to other provisions of the Constitution. Now, anyone want to take a stab at what are they suggesting then? Harmonious method. Does everyone understand? So that really is the key thing for you to keep in your mind, that the literal meaning is really only of use where words are plain and unambiguous, where it's absolutely clear what the word means. Okay, so a word like citizen, we all know what it means. You have citizenship of Ireland. It's plain, it's unambiguous. Okay, now, however, where we've doubt or ambiguity, the court acknowledged the literal method can't use, and they suggest we look to other provisions, which is really the harmonious method. Okay, so what happened then was, then we start to see alternatives to this literal method coming out. And one of those alternatives was suggested in Attorney General versus Paperlink, which is 107 of your manual. Okay, now what we have here is the judge in this case, in the Paperlink case, which dealt with the right to earn, he had to interpret the right to earn a livelihood. And what the court here said, if you look at the middle of the quotation, it says, a purposive rather than a strictly literal approach to the interpretation of the subparagraph is appropriate. Okay, so what the judge was advocating there is, look, he said, I can't use the literal method, it doesn't work for me in this case, so I'm going to use the purposive method instead. I'm going to try and look at what is the purpose behind this constitutional provision, namely the unenumerated rights, personal rights, where the right to earn a livelihood comes in. Everyone okay? So what the judge there rejected literal approach as not being appropriate for this case before him and said he was going to adopt the purposive. Now the manual goes on then in 108 to tell us the problem with the purposive. And what do you think the problem is with using the purposive approach? Working out what its purpose is. Okay, there's two possibilities.